himself. Some of you may be wondering why we're here. Well, we're here because I, this morning, woke up and actually had a tiny little bit of time before I had to run out to work. So I was able to watch Mr. Capaldi's video with Mr. Hodnott. And there was something that very interesting that came up in that video. I've seen this question asked a couple times. Some people are just not understanding where and when the state agreed to do all this further testing. So they don't remember seeing it. They don't remember exactly. Well, I'm going to show you and remember you today. Anyways, so member, right? So for those South Park fans, but anyway, so what it comes down to is we're obviously talking about the judicial estoppel argument that we saw in the recent reply to the state, right? So obviously we understand what that means. That means that the state can't take one position on a case or whatever early on, and then suddenly as time goes by, they find another stance maybe more favorable to them at a later point. They can't just switch. They can't just switch to a different what you might want to say, different tack or whatever you might want to say, but they're basically going to switch their polar, they're going to go to the polar opposite essentially. So in this case, that means originally the state was on board to do more testing of more of the evidence. There was talk of a 4-week evidentiary hearing, as you'll see here today, and all that sort of stuff was talked about. And that was all agreed with Zellner and Fallon and all those guys. They'd gotten together. The agreement was made. As you'll see today, it was made in September, late September. And that is basically just 2 weeks before Judge Angie denied the motion for post-conviction relief. So we know that this agreement was going on in September, about 2 weeks before the denial. What was taking Thomas Fallon so long to coordinate getting the rapport to Calumet or whatever? That'll be questions that we might have for today's live. But what took so long, to get that together so that Zellner could get something filed with the court before that happened? Well, I don't know. Obviously, in terms of the legal community thinks that how that all went down was just fine. I think in logical terms, I think it's stupid, but I guess legally it makes sense to legal minds. But the point is that they were willing to do those things. They weren't arguing procedural bar. They weren't trying to stop every single thing that Avery did. They were actually willing to work with him. And then now that their only argument is procedural bar, that is essentially the opposite of what they were before. And that basically going to the extreme opposites like that because it suits you is blocked by judicial estoppel. It's meant to maintain consistency through the litigation process. So somebody's talking about your hair now, Paul.
No, it's not all about my hair. And I'm sending you a picture of another question that was raised. I asked Mark Hodnott about whether we could get any pictures of Lisa Comfer, and none other than Stacey Seabrook has supplied us with a picture, which I have just sent you. So we can.
You've just sent me.
I've just sent you the picture of Lisa Comfer. Because I couldn't find anything at all about her. I couldn't find a thing about Lisa Comfort. And you know what I'm like. I'm one of these. I'm always looking for information. So this is what Stacey sent me.
All right.
This is Lisa Comfort.
All right, here you go, folks. I'd like to ask that all 14-year-old children please leave the room.
Yes.
There we go. It's an incognito name for somebody we maybe know.
Yeah.
So, all right. So getting back to what we were talking about here.
Yeah.
And no worries. So that's what we're talking about now. Why now? So how do we know that the state agreed to all this testing and a 4-week evidentiary hearing and getting the RAV4 down to Calumet and all these things that we've heard, or that you've heard, that you may not have seen the proof on. It's so how do we know these things? Well, we know because on October 3rd, Judge Sukowicz denied, October 3rd, 2017, Judge Sukowicz denied Avery's 97-406 motion for post-conviction relief. That's the big 1,200-page thing, folks. Remember all that big to-do? 1,200 pages, all that? Right. Okay, that's that one. So on October 3rd, less than 3 months from when it was filed, right? Right? Anyway, so it's denied on October 3rd, 2017. On October 6th of 2017, Zellner filed a motion to vacate the ruling.
Yeah. And
in that motion, she lays out everything that her and the state had been talking about and had agreed to, and had actually already agreed to it about 2.5 weeks prior to the Judge Sukowicz's decision. And they had been talking about it, but for some reason it was taking the state a long time to get the RAV4 to Calumet, apparently. And it was because of the logistics of that Fallon didn't end up putting in, they didn't end up filing with the court. It sounds like a mess, and it sounds like probably blame on both sides, but the fact of the matter is that Fallon and them took a long time, and it makes me wonder about those people that say that they don't know if the RAV's there anymore. Why did it take over 2 weeks to drive the RAV4 from Milwaukee to freaking Calumet? It shouldn't have taken that long to drive a car from Milwaukee to Calumet. Seriously. I mean, I've never received a proper explanation for why that takes so long. But anyways, what we're going to see here today, folks, is I'm going to show you that motion that Zellner filed on October 6th of 2017. And you're going to see all the things that are agreed to. Now, just because Zellner says it in this brief, is it true? No, not necessarily. But the fact of the matter is the state didn't oppose any of this. She filed this with the court. Of course, Judge Sukowicz denied it. She wasn't about to vacate her judgment or her order about the 97-406 motion, but she did read this, and the state didn't try to oppose it. So even Judge Sukowicz determined that the agreement must have been in place because the state didn't oppose it. Right? So we're going to go through what was agreed today. Anything else, unless it's more pictures?
Well, no, I'm just puzzled, as you say, as to where this RAV4 is. Was it not the aliens took it away with them?
Right? Yeah,
I'm sure
these aliens. Yeah, there you go.
Sure that's where it ended up. Did it not end up somewhere on Mars? Or?
The Mars rover is actually a RAV?
Well, maybe, yes. Yeah, 4x4, very handy. Very handy for up there.
So, right. Okay, so let's look here. I'll read through this a bit, folks, and you can see how it was all basically agreed. So, motion for relief from the judgment or order of October 3rd, which is the one I was just talking about, pursuant to Wisconsin Statute 806.07. Now comes defendant Stephen Avery by and through his attorneys, Kathleen Zellner and Stephen Richards, for his motion for relief from judgment or order of October 3rd, 2017, pursuant to Wisconsin Statute 806.07, states as follows. On October 3rd of 2017, this court entered an order dismissing defendant's motion for relief filed on June 7th, 2017, pursuant to Wisconsin Statute 97406. Defendant hereby moves for relief from that order pursuant to Wisconsin Statute 806.07 due to matters pending at the time the order was entered. At the time the order was entered, the parties, through defendant's attorney, Kathleen Zellner, and Assistant Attorney General Thomas Fallon, had an agreement that further testing would take place on certain evidentiary items. The parties also had an agreement that the previously filed 97406 motion for relief would be amended. On September 18th of 2017 in Madison, Wisconsin, the parties reached the aforesaid agreement. So September 18th of September, that's just about 2 weeks before, you know what I mean? That's right around 2 weeks before the motion to deny it, or the order to deny it. Defense counsel Zellner and Johnson, together with prosecutors Fallon, Norm Gahn, and Mark Williams, specifically agreed as follows. The RAV4, Wisconsin State Crime Lab, WSCL, Item A, would be made available to defendants' experts, Doctors Carl Reich and Christopher Palahniuk, for examination at the Calumet County Sheriff's Department for additional items to test and for collection of swabs from the A, battery cables, swabs previously collected and designated WSCL items IE and IF, swabbing the bar under the driver's seat, swabbing the hood crutch, the hood prop, swabbing the interior door release, and a complete examination of the interior and exterior of the RAV4 for additional forensic evidence. Prosecutors stated that they would schedule the examination of the RAV4 testing in the very near future before the weather worsened, but still took over 2 weeks to drive the RAV4 to Calumet. Okay, all right. Anyway, the prosecutors also agreed that the defendant would be allowed to attempt testing of the license plates, WSCL items AG and AK for DNA. The prosecutors also agreed that the defendant would be allowed to test the lug wrench. The prosecutors agreed that Doctors Stephen Symes and Leslie Eisenberg would be able to do a microscopic examination of the pelvic bones located in the Manitowoc County gravel pit. Prosecutors and defense counsels also agreed that to streamline the litigation, defendant would amend the petition. It was generally agreed as to what claims would be added and removed from the petition. Additionally, prosecutors and defense counsels agreed that if an evidentiary hearing was necessary to resolve the issues in the amended petition, the evidentiary hearing could last 4 weeks or more. Scheduling was discussed, and prosecutors and defense counsel agreed that the evidentiary hearing could be started in the spring and could proceed during the summer to completion. Defense counsel agreed to remove the issues of ethical violations perpetrated by prosecutor Ken Kratz. Defense counsel also agreed to remove the references to brain fingerprinting test of Stephen Avery performed by Dr. Lawrence Farwell. Defendant intended to inform the court that an amended motion would be filed so that the dates for a scheduling conference for an evidentiary hearing, if needed, could be set. Defendant did not anticipate the court filing its order prior to the time the defendant could notify the court of the matters set forth herein. So she's basically saying we did not expect this order to come through so quickly. And there's something to that. Because, on that 1,200 page motion, she took less time than she did on many of the other supplements. All these things that were, much less material to go through. And she took a lot longer with some of those. So it does beg the question. Anyway, on October 6th of 2017, defense counsel spoke. The prosecutors informed them that this motion would be filed today to vacate the order. This motion has been presented to and reviewed by the prosecutors, and the prosecutors agreed to the factual accuracy of the representations regarding the content of the September 18, 2017 meeting made in this motion. So, folks, the prosecutors read this before she filed it, and they signed off on it. It's not any more agreed than that. It couldn't possibly be any more agreed than that. And so, for those of you that want to read through this yourself, the link is down below. Okay.
Is it?
So, one other thing I want to talk about real quick, Travis brought to my attention recently, so I want to go ahead and straighten this out for everybody. I had said I'd gotten maybe a little bit confused previously and had told you guys that there was a letter that was filed right before the decision came through. I after going back and looking, and that's why I want to correct this, it turns out that letter was filed on July 14th of 2017. So in that sense, it just means that Judge Sukowitz was aware that the attorneys were talking about doing further testing as early as July 14th. So for me, it makes very little, it makes very little difference in terms of the timeline of events. Judge Sukowitz understood that Zellner and the state, the prosecutors, were discussing doing more testing. This 1,200-page motion for post-conviction relief got decided quicker than a lot of other 80, 90-page supplements. You know what I mean? So there's some how would Brendan say, wonkiness going on with this. So, but I did want to show you guys, and this letter is also linked in the description below. But you guys can see that in this letter there is discussion of testing that they are planning to do. The cranial fragments and stuff like that, all getting mentioned in here, and so Judge Sukowitz had some inkling that there was some what do you want to say? There was some negotiating going on. Okay, and it just makes it all that more odd when her decision came through as quickly as it did. But wanted to go ahead and clarify that the letter didn't come through like the day before or days before. It was actually about maybe 2 months before. So, to be fair. You guys are all just talking about freaking whiskey.
No. I wasn't talking about whiskey. I was asked a question. I gave a civil response.
It looks to me like it's whiskey.
Yeah. Take us back, though, to this. So Kathleen Zellner filed, and they were in the process, her and Tom Fallon, in vacating a motion.
Say that one more time.
They were vacating the 9746 motion.
Right. This was meant to vacate the motion. Right. They were trying to vacate the Judge Sukowitz's order denying the 97406. So that's what they're trying to do. They're trying to vacate her order of denial.
No, you've lost me, Dave, because like Kathleen Zellner in August, she put forward a motion for scientific testing, and the state agreed to scientific testing. And as far as I can see, most of the stuff that she was given was stuff that was at the state crime lab.
What they agreed to in the first, yes. Well, okay. What was agreed to be tested?
10 items.
Thing, yeah, that was one thing, and and she was testing those things, and it's because of those things. That's what the original 97406 was based on, was the testing of those things. That's where all the findings of that evidence were coming in through that 97406, and what happened though is that she was now negotiating with the state to test more things.
Yes,
skull, cranial fragments, RAV4 hood prop, bar underneath the seat, and all that other things you heard her talking about. So now they were talking about doing more stuff. Okay. And like I said, it's in the letter. The testing the cranial fragments is in the letter on July 14th that I was just talking about. So there is this negotiation happening. And like I said, the October 6th order or motion to vacate that Zellner files is laying all that out and laying it out that, yes, this agreement was happening. This negotiation was going on. Nobody expected the decision to come through this quickly. And I think there's a lot to that. Like I said, just because it was 1,200 pages, it was bigger than anything else, but it seemed to take the least amount of time to deny it. So it's interesting. How's it going, T1? What's up, dude?
Yeah, sorry. So just to make, sorry to go on about this, just to make it absolutely clear. So Zellner filed a motion asking for scientific testing.
Originally,
and she was given 9 or 10 items,
right?
Okay, which were easily handoverable, if you like. They were easy enough for Sherry, bless her, with a mop of hair to. Talking about mop of hair. Anyway, we're digressing. Right. So that all this stuff gets handed over. Although there was one item I believe that got split. And we see that in Making a Murderer too. Yeah.
That was one of the swabs, right?
Yes. Okay. So then, certain amount of testing is done, And then Kathleen Zellner files a motion.
She files the 97406 after the testing is done. Yes, she files her 97406. That's where she's laying out the wood particles in the item FL and just all the brain fingerprinting, all that stuff that she had done. Carl Reich and his DNA stuff. Dr. Symes, all this stuff. She was laying out all this stuff that they had determined and that sort of thing. So that's what got into the 97406 the first time. But then, like I said, they were now talking about doing additional stuff, and they were going to amend the original motion. So that's what was being talked about. And so, but like I said, it's the important thing here, folks, is if you were in any kind of quandary as to whether or not an agreement actually existed, you now know it did. It totally. Yeah. You can see right down here. Guess who's CC'd in this? Even if she didn't take it to him beforehand, like she said, he's still CC'd on it. So no matter what, he's seeing this. Mm-hmm. And the state would have had ample opportunity to respond and say, oh, this is an absolute pack of lies. But they never did. So.
Yeah. So to carry on, the testing was done. And then Kathleen Zellner filed her motion because she said, basically, yes, there might be stuff I want to add to this at some point, but at the moment, it's as complete as it can be. And I think we hear the Stephen Richards say, I know you're always looking for something new, even on the day itself. There might be something new that you might want to add in, but I think she said, this is as good as it gets at the moment. So, I'm going to go with this.
Right.
And then apparently the allegation was that she didn't keep in contact with the judge to say that these negotiations were ongoing with Tom Fallon. Is that right?
Well, that's it. Somebody from one of the camps needed to file something with the court saying we're discussing amending the motion or something. Then most likely Judge Sukowitz would have just put a stay on it or, just something until they worked out all their testing and all that stuff and returned to amend it. And then, then she would have, okay, remove the stay. You want to file your amended motion now. Okay, whatever. That would have happened. So why nobody filed anything with the court is, I don't know. Amazing.
Well, I mean, yeah,
it sounds to me like Zellner was just kind of trusting to Tom and Fallon and that, but I think she honestly also didn't expect a decision for at least another couple months.
Exactly.
I mean, I don't think she was feeling under the gun at that time, so I think that's anyway. But yeah.
It was an incredibly sneaky move.
Yeah, I think so.
And it was. And was it not within days of Tom Fallon getting in touch with Calumet, because that's where the RAV4 is in storage in Calumet County?
No, they were going to be bringing it to Calumet so that Palahniuk and what was she saying? Carl, was it Reich and Palahniuk? I think. Anyway, there was two of them that were going to go to Calumet, and that's where they were going to do it. As far as I understand, the RAV4 is in a storage in Milwaukee, an underground storage somewhere in Milwaukee.
Right. No, it's just that some of the evidence, like they were talking about evidence bags. Fallon and Mark Williams were talking about evidence bags being in Calumet County.
There may be some evidence bags that could be there. Sure.
Like, these bones, that's what this message that Mark Williams inadvertently left on Zellner's phone.
Well, that was funny.
Wasn't it?
He didn't really mention anything other than the fact that he thought he was talking to Tom Fallon, mm-hmm. and he's basically saying, so I guess they're just saying, don't even talk to her. Don't even answer her. Don't even... Just don't let her, don't even talk to her or say anything. Just whatever. Like, it's basically like, just climb up. But it's like, he's saying this on her voicemail. Yeah. It's just like, yeah. Oh boy. Yeah. Yeah. You got to wonder about how that happened. I mean, but yeah, it happened. they somehow ended up leaving Zellner a voicemail about how big of douchebags they are. So
our Aussie friend Henry's got a question.
Henbury. He says it's for you. Let's see. Who has the bigger sweat problem right now? King Kratz or Prince Andrew?
I think they are both in the same amount of SH1T. And I think the arrest of I always thought it was Ghislaine Maxwell, but apparently it's Ghislaine Maxwell. She was arrested. She was found and arrested. So I think she's going to be vital to getting this sorted out. And yeah, let's hope that Prince Andrew gets deported to America, and in return, Donald Trump sends us Anne Secoulis.
Right. Jennifer Manning. Aha. You were the one asking the question on Paul's Live this morning. So you're saying, can this mishap go against SA? So I'm assuming you're saying mishap in terms of the fact that nobody filed anything with the court, and Judge Suk's denial ended up standing. That can't go against Stephen Avery again because it's already gone against him. So that's already in the past. It went against him. She filed this order to vacate, which Judge Suk denied. But in her denial, she couldn't help but acknowledge that there clearly was an agreement between the state and Stephen Avery. She acknowledges that when she denies the October 6th motion to vacate, she basically acknowledges the fact that the agreement does exist. That's all that's important here, Jennifer. The agreement does exist. So that's the big takeaway here. In terms of this working against Stephen Avery, it's already worked against him. It's not really going to work against him again. Right now, the important thing is the state did make this agreement with Zellner, and they have basically flip-flopped and turned about face on it, and they are now arguing the opposite way. And so that is why judicial estoppel was created, to prevent that kind of disingenuous ethics from any lawyer. It could happen to the defense too. If Zellner were to suddenly flip-flop what she was saying and start arguing a completely new thing, the state could argue judicial estoppel against her. You see, it applies to everybody. But if you want to flip-flop on what you're arguing, judicial estoppel could be coming your way. So
T1's got a question there.
Motion is being brought for a 3-judge panel, correct? Yes. So does that need to be a unanimous decision or a majority? That's a majority decision.
Is it a 3-judge panel? Because so far it's only Judge Paul Riley who's.
That's just on the motions and everything, whatever. When they actually decide it, it's going to be decided by 3 judges.
Well,
same thing with like with the 7th Circuit. Like
when you got the hearing.
Well, yeah, but it's a little different situation there because they're supposed to have like 11 judges. Yeah. So it's a little bit different. So there you do talk to a 3-judge panel, even when you're filing motions. Like if you're asking for motion for bond for Brendan and whatever, that goes to a 3-judge panel. But that's because they have 11 judges on staff, and so these motions and these things will go to 3 judges. But obviously, and it's a little different at the federal court, but essentially there's always going to be basically 1 judge responding. And you can even see that in the decisions usually. There's 1 judge that makes the decision. Sometimes you have a second affirming opinion, and then you'll usually get some dissenting opinions. That's the way it goes, right? You'll hear from the judges that want to be heard. You know what I mean? So
But so far it's been Judge Riley who has so far been the one that's been the one that's sort of keeps sending it back. He sent it back to Angie twice, hasn't he? Right,
for the CD and for the bones, right?
So I mean, eventually he's just going to get. And you can tell by the tone of his previous decision.
Yeah, and I gotta say, folks, I mean, for me, I'm thinking that the appeals court judges remembered Kathleen's judicial estoppel argument from before.
Yeah.
before now. I think they were taking that into account long before when she originally argued it, because when the state came arguing procedural bar about those damn bones, Riley didn't like that at all. Riley was like, "Oh, hell no." You're sitting here like, you're arguing procedural bar. You're telling Avery he should dismiss his current appeal to take up, this issue, and which is the exact opposite of bringing everything under one umbrella. I mean, you could tell that that judge at that point was just going, "You guys are out of your freaking minds." And that's when they remanded it with the specific instruction of arguing it on its merits and not on procedural bar. So it could be that the appeals court judges are already taking judicial estoppel seriously.
The comment by William.
Yeah, he's a cheeky bastard.
Well,
I like him, though. He's the guy.
Yeah, it just reminds me about the you heard about the case of the fellow that woke up in accident and emergency, and the nurses say to him, "Well, you're lucky to still be alive." So eventually, this doctor comes along and says, "Well, I'm really sorry, pal, but in the accident, you lost your manhood." The good news is that we're one of the only hospitals in the entire country that can do a manhood transplant, and we've got 3 in the fridge that we could transplant out here. One of them is a standard English sized, good to go, but it's £3,000. But for £4,000, we've got a Scottish one that's been under a kilt all its life, and for £5,000, you can get a West Indian. So the guy says, "Well, I'm going to have a word with my wife and see what we decide on." He says, "Oh, that's fine. Take your time." So 15 minutes later, the doctor comes back and says to the guy, "So what have you decided?" And he said, "Well, we've decided we're going to get a new kitchen."
Right.
That was just a comment about the sausages.
See, I don't know. I'd be coming back into that doctor's office saying, "So we've decided to get a divorce." Anyways. So there you go, folks. I mean, I just wanted to show that for anybody that hadn't, that was in question, wasn't sure about this agreement that existed or whatever. I hope I've cleared it up for you today, because the agreement existed. Zellner tells you right there in that motion to vacate that the state prosecutors, Fallon and all them, got to read this thing before she filed it. So the fact that they offered no opposition, folks, tells you it all. You need to know. Yeah, it's
I mean, what do you see as being the next options? Because one of the things that Mark mentioned, of course, was the fact that they could just decide, the appeal court just say, "Look, just vacate the conviction." You are so in a hole.
Right.
You have no chance whatsoever. You've had your bit of fun. You are completely where you are now. You're in a canoe without a paddle. You're just completely lost.
Mm-hmm.
That it's going to be interesting to see what happens next, isn't it?
Yeah. I mean, I think I heard you talking with Mark about that, and as much as I would love to see what happened with Ryan Ferguson happen here, I don't know that it will. But if it did, great. But I think it's most likely headed for an evidentiary hearing. That's really where I think this is going. And why do I think that? Because in one of Judge Sukowitz's, I think it was a decision on the bones. Yeah, that's right. Some of you may remember our good friend Rule Griffin. And he wrote a great song about this, by the way.
Yes.
But basically, in her decision, folks, she was arguing the case. She wasn't okay. Judges don't argue the case. You understand that, folks? That's not what judges do. That's not their job. Okay. But in her decision, she was arguing for the state. And so Rule wrote this song called ADA Sukowitz, and it's brilliant. If you guys haven't listened to it, go give it a listen. It's freaking hilarious. But yeah, we love Rule. Rule hasn't been around much lately, but we still love Rule. And yeah, and so he wrote that song, ADA Sukowitz, Assistant District Attorney Sukowitz. That's the type of stuff that I think is going to stand out to the Court of Appeals, where they're going to be like, "Oh, what the hell is going on here? Why do we have a judge arguing the state's case?" Right? And so, I think it's things like that are really going to really cause this thing to be just unavoidable. I mean, the Court of Appeals is, I think, really going to have to take this seriously.
The question, why is Angie doing what she did? Apologies, I had to go and shut the door because the wife's put the washing machine back on again. So apologies for that.
No worries. Yeah, I know that joke, T1, except I tell it differently. But for me, they're in court at a divorce hearing. And anyways, but funny joke.
Yeah.
She's not crazy. She's effing goofy. There you go. So.
But the big point of the issue here is that not only do you would imagine that within Wisconsin, certainly between Calumet, Manitowoc, and that area, you've got Judge Angie Sukowicz, who's based in Sheboygan. You had Ken Kratz based in Calumet, Appleton. It's that side of Wisconsin. They're in pretty close proximity. So not only would they know each other through normal legal circles, but as Ken Kratz likes to point out time and time again, he was chairman of the Wisconsin Crime Victims' Rights Board. And there's not many members on that board. And who was one of the members on the board before she was judge? Angie.
Right.
And when she was just a lawyer, she was also on that same board of I think there's only about 9 people.
Yeah. And it's a complete wank anyway, as I've told you. You guys, I told you the story about Steve Arado from Eagle Nation. Yeah. He actually ended up, going before the human that Crime Victims' Rights Council, and it was a complete wank. They found the judge had violated his rights and basically just said, "Oh, don't do it again." That's it. That was it. What was the point? Why did you even waste everybody's time gathering them together at this nice hotel to do nothing about it? I mean, it's just like, oh my Lord.
Well, I can tell you why. Because by doing the judge a favor there, you'll get a favor in return.
Well, and it's the same judge that ended up, denying denying one of their lawsuits and stuff, and stuff like that. So it's not good. But we don't know where Kratz is now. Kratz is in hiding. He finally got the good sense to shut the hell up.
Well, I think he's expecting a call off the FBI sometime soon, isn't he?
Yeah.
I think
the sexting scandal.
Well, no, I think about his whole carry on in this case, because I think eventually it's all going to go. It's going to be huge. Mm-hmm. When you've never in the history, as far as I know, had somebody like Stephen Avery, who's about to be exonerated for a second time,
right?
And who was convicted the second time because of the wrongful conviction the first time,
right?
In
a lot of ways, yeah.
I mean, this case is, it's just huge,
right?
It's got huge implications.
Hey, Drew Gagini. Long time no see. Hi, Tammy Lee. Hey, hey, Kay Parnell Sanders. I just want to say hi. Hey, Dark Side. Some of these people I hadn't said hi to. Hey, Bridget. Addiction Mouse. How's it going? So I want to let you guys know, obviously we've covered all this and we've talked all about this. Now, for those of you who don't know, Paul, and I believe you have Silkman, and do you have the Hod joining us?
We've got, well, let's go in in sort
So we're
of.
talking about Saturday, folks. Talking
Yeah.
with Richard Leo, and we're going to have this many people with us. Paul's going to go ahead.
Well, we've got Richard Leo, obviously, Dr. Richard Leo, who wrote an affidavit about Brendan that Judge William Duffin basically based his acquittal decision on. We've got ladies first. We've got Tracy Keogh, obviously huge Brendan supporter, who also I understand has spoken recently with Dr. Leo, so that's good.
I saw on a tweet of hers recently. He was on 6th Hour with her. So
yes, that's right. We've got the Hod,
right,
Dr. Silkman,
okay,
you and me.
all right.
Yeah.
You never told me about Tracy.
Sorry?
I said you never told me about Tracy. I don't mind though. I love Tracy.
When did I not tell you about Tracy?
Well, you told me about Dr. Silkman. You told me. I remember. I heard you mention the Hod, but I never. I'm just finding out about her. So.
Well, I'm just keeping her as a little surprise. You see?
There you go. Well,
there you go.
So, folks, that's an all-star lineup to talk about Brendan. I'll tell you that right there. So,
well, Brendan and also obviously, coerced confessions in general. I think is obviously what we're.
I'd actually like to ask him about how those same, how some of the principles that apply to false confessions might also parallel situations interviewing victims and things like that. And I think you might get an idea of why I'm asking that. But anyway.
Yeah. Yeah, I mean, it's obviously, as I said to Mark earlier, when once Stephen and Brendan are out, and it could be incredibly quickly,
right? Maybe
it could be,
maybe,
yeah.
So
then it is full steam ahead on this Daniel Holtzclaw fiasco.
Yeah, that's what
absolute
it is.
Fiasco.
Yep.
But at least what I was encouraged to hear was that you were saying that because there's this civil suit being brought by the women who have accused him and who were successful at court.
Right. Well,
yeah. Although,
well, yes, the women who he was found guilty of the charges they had.
Yeah.
Right.
Although you wonder how much their lawyer. You seriously have to wonder the ethics of the lawyer for these women that's bringing this case forward.
Right. That is probably
I have to seriously wonder about this guy's ethics. If he thinks that because they got this conviction of Daniel, then they are then entitled to all this compensation.
Right.
Compensation for.
That's what it was all about in the beginning, though, Paul. I mean, that's the one thing I keep pointing out here is that they can't, because that's what these investigators were doing. They kept dangling this attractive piece of bait in front of these women who were from the low-income areas of town. They weren't exactly, the monopoly man. You know what I mean? These were people that had rough lives, and so you go dangling this bait of, if you tell us this officer was bad, blah, 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 we'll get rid of some of those tickets for you, or we'll make this warrant go away, or you might actually have a potential civil suit in the future that you could bring. You understand how when you're doing it like this, you're putting this huge carrot, this huge prize in front of their face. And I mean, of course, what do you think they were going to do? Of course, they're going to be like, oh, yeah, okay, yeah, he did. He totally did those things. He did this and that. And folks, I don't know if any of you have been watching my Daniel Holtzclaw stuff. I have one starting today, a half hour before Millbillies Live, unfortunately, but, it is what it is. So, but today's is going to be about a 2-hour long one. And Mitch and I are going to be doing some commentary as we listen to a couple of Brian Bates episodes. and we're going to be doing live commentary over while we're listening. So that's what tonight's going to be. It's folks, this one tonight, this 2 hours is packed with where you can really see the investigators were doing wrong. They knew they were doing wrong. They knew what they were doing was wrong, and they were still doing it. And then you even get to see them tell a lie to cover up some of their past misdeeds. You actually get to see that. So it's important in that case, but I don't want to go on too much about that here. I hope to see you guys there on that one. I will tell you guys this. I'm getting ready to record with Mitch and Paul again for tomorrow night's Daniel Holtzclaw premiere. And in that premiere, folks, you will be able to hear from Daniel Holtzclaw himself. I have a special clip for those of you who are interested. And you'll be able to actually hear from him. So that's what you guys can be looking forward to tomorrow, along with Mitch and I and Mr. Capaldi, and we'll be discussing this. So that's what we're going to be doing after this. I hope you guys found this interesting. Obviously, the judicial estoppel. I know everybody, it's a great argument. And I get it why some people were thinking, we're worried and we're wondering if the agreement actually existed. It existed. It was there. It fully existed.
Oh, yeah.
So any of you that were worried about whether it existed, you don't need to worry. It totally 100% existed. And so that's where we're at. So. See, that's why the Hallbox dropped their shit. Let's see for Erekose. So what's next now? KZ has filed again. What's next now, folks, is that's it. KZ filed their motion. So I'll give you guys a brief thing before we go here. KZ filed the motion to appeal originally earlier this year, long time ago. and then she filed her motion, and then we finally just got this because of COVID-19 and all kinds of delays by the state and everything. We had to wait a long time, and we finally got the state's response in what was it, end of May? Mm-hmm. Right? So, and then finally we got the state's response, and then within about another 30 days we had Zellner's reply. So that's basically it. That's the motion is now what they call briefed.
Yeah.
So it's now briefed, and it's before the judges, and the judges are now going to decide on the issues. They're going to decide whether there's an evidentiary hearing coming. They're going to decide whether or not to just free Stephen Avery altogether. If they're just like, this is a mess, they could just cut him loose, similar to the way that they did with Ryan Ferguson. I wouldn't say that that's a likely option, but it's possible. It's an option that they have. But I would say that this thing's most likely headed for an evidentiary hearing. That's just, to me, my gut tells me that's where it's headed.
I'm just wondering, by what's next? Are they meaning like you getting your haircut?
Yeah, I need a haircut, folks. Paul
That's where the
is not letting me forget. Him and Eunice are not letting me forget. I want to get a haircut. Trust me, it's getting hot, and this mop on my head is driving me insane. But with COVID-19, it's a little harder for me to get my damn haircut. But yes, I intend to get it as soon as possible opportunity.
You've got an image to uphold. You are a dedicated follower of fashion. You are.
Oh yes, that's me. Fashion plate.
Exactly.
That's me. Yeah.
You don't get to be as cool as you without having to suffer, dude.
You should have seen Denise Rainey looking sideways at me in Manitowoc when I was wearing my shirt and tie with my cargo shorts. I think her eye was twitching. So, anyways, we love Denise Rainey, folks.
Yeah,
we miss her. She passed on recently, but yeah, we love Denise Rainey with all our hearts. So, yes. All right, folks, just so you know, I do have a premiere coming up for Daniel Holtzclaw in 1 hour. For those of you that are interested, didn't know Mill Billy was going live 30 minutes later. I'm sorry about that. But if you guys, for those of you that want to catch up on Daniel Holtzclaw, I did see your question, the person that asked. I have on my channel, if you search Daniel Holtzclaw, you'll see videos come up. My videos start with one where I said a brief overview or a brief look at the Daniel Holtzclaw case, and that's where I basically go through a summary written by the public, the PI, the private investigator that was hired for Daniel's defense, and he writes this summary of all of the various issues in Daniel's case. So you can watch that video. I've done now several videos. I'm probably like 12 videos on Daniel Holtzclaw now. I've already covered 7 of the accusers. There's 6 accusers to cover. Tonight's video is going to be covering the arrest of Daniel Holtzclaw, the ridiculous bond that was set for him, and then it's going to go on into talking about the false accuser that came forward shortly after Daniel was arrested. It's very, very strange where we're going to see an investigator who has been failing to do his job in questioning these accusers. He's been very lackadaisical in his job, but as soon as he gets this lady that comes forward after Daniel is arrested, and it's all in the media, this lady comes forward and gives a ridiculous story, and he just slams her. He finally starts doing his job and asking the right questions, and he totally susses her out as a fake. And it's like, where was this, Rocky Gregory? The last 6 people that came in. You know what I mean? It's like, where was this guy then? It's just bizarre to watch. So for those of you that are interested in the Daniel Holtzclaw case tonight, it's about an hour and 50 minutes, but it's a good one. It's got a lot of good information that you will find very interesting. So, and then, like I said, tomorrow's premiere, you'll be able to hear from Daniel himself. I have a little clip from Daniel himself. So we're going to be recording that now as soon as we're done here, and then we'll uploading that for tomorrow. Everybody out there, hope you found this interesting. The judicial estoppel argument is awesome. The agreement existed. So rest assured, Kathleen's arguments are kosher. They're on point. So, all right. Anything you want to say, Paul, before we go?
It's good night from him.
Yeah, it's good night from No. That's not how it goes, dude.
Oh, sorry. Yes.
See,
if you haven't done so already, please hit subscribe.
That'll do. Bye, folks.
See you later.
Like I said, I have my premiere in about an hour if you guys are interested. And like I said, but thank you for being here, and we'll see you later.